You know, a lot of talk these days, but not necessarily a lot of focus on the actual law that would be used to potentially prosecute here or try to wage a successful case against a number of these companies. Do you think that case can be made?
Well, I think it's very possible that an antitrust case can be made, but you have to understand that antitrust law is not a general tool that can be used to attack big corporations or even economic power. An antitrust violation requires finding both anti-competitive conduct, which means conduct that doesn't really benefit the economy, and the creation of market power as a result of that conduct. And I think in all probability, if there are going to be violations, they will be quite narrow and specific violations involving certain kinds of conduct on peripheral aspects of the basic business models of the big techs, the big platforms.
A number of people want to try and draw parallels to the government's case against Microsoft, but there it would seem there was potentially truly competitive violations that were more or at least easier to see. Do you agree?
Well, I'm not sure they were easier to see before the investigation began. The government has tremendous investigation powers to get evidence, see documents, take testimony, not only from the target of the investigation, but from third parties. And after an extensive investigation, the government did come up with substantial evidence of anti-competitive conduct by Microsoft. Whether that will happen in these cases remains to be seen.
What do you think is going to be scrutinized here? Is it digital advertising or other parts of the businesses?
Well, I think the question will be, did any of these companies engage in conduct that harmed competition? So that could be aimed at competition in what might be called adjacent markets. For example, the allegations that Amazon has somehow engaged in improper conduct to move into product spaces and displace vendors that have been using its platform. Or it could be aimed, as the Microsoft case was, at conduct intended to nip in the bud threats to the core business, the search platform in Google's case, or the social network in Facebook's case, or the product platform in Amazon's case. The latter, I think, is less likely, but I'm sure the agencies will investigate that.
A lot of people say that, you know, it's going to be hard to build an antitrust case because consumers like these companies and they provide services for consumers. And we haven't really seen much of a pushback against Facebook or Google when it comes to consumer choice. Is that part of the argument or not?
Well, that certainly will be an argument, but that's a very limited antitrust significance. By the way, I think the consumer ratings right now of Facebook are not that great, but certainly what you said is true about Amazon and Google. But the antitrust laws are not concerned, as some critics have, I think, mistakenly said, with short-term consumer benefits. They're concerned with maintaining a competitive environment. And if those firms have been found in some particular respect to have engaged in conduct that erodes the competitive environment, they could be found to violate the antitrust laws, even if consumers are happy with the product.
Some people look at the acquisitions by Facebook of Instagram and or Google by YouTube. Of course, they were both years ago, and these were very small companies, and they've grown into incredibly powerful parts of the overall companies. But say that there should have been more done then. They shouldn't have been allowed to have been acquired. Do you think that DOJ and to a lesser extent FTC, of the antitrust enforcers, should have had a sharper edge when it came to allowing certain acquisitions by these technology titans?
Well, perhaps so, although I'm not prepared to say that those acquisitions should have been prevented because I don't know the facts in great enough detail. I do think antitrust law has probably been a little under-enforced in the past couple of decades, and some incremental adjustment in the laws are appropriate. But the challenge to those raised by those mergers are extremely difficult because you're taking small companies that do not compete head-to-head with the acquiring platform, and you're asking the agencies to project whether the acquisition will nip in the bud a competitive threat on the one hand and perhaps be anti-competitive, or on the other hand will enable the assets of the acquired company to be used in their most efficient and economically valuable way. That's a very difficult enterprise. So even with some adjustments in antitrust law, it's not clear how many acquisitions of that type would be prohibited.
Yeah. And finally, you know, there's been an argument made that the presence of these incredibly powerful platforms stifles innovation by stopping the flow of capital that might normally go towards companies that conceivably would compete with them, because there's just a belief that, well, you'll get stamped over by any of them. Is that something that could be part of an antitrust argument?
Well, I think the economic studies do tend to show that substantial economic power tends to be a detriment for innovation, in part for the reasons that you said. But antitrust law is not used simply to attack big firms, whether they're expressing their power by suppressing innovation or by increasing prices, but rather antitrust intervention depends on finding bad conduct by those firms that led to their market power, and that's going to be the challenge facing the agencies.